Yes, my name is Dee Jenson, and I'm here representing my family and friends of Rhode Island, and on behalf of my nephew, Mario Montero. He is an inmate at the ACI serving 2 life sentences, and I'm testifying, of course, in support of this bill. I want to thank Chairperson Lynch Prada and the Senate committee members for the opportunity to speak today. I appreciate and we are all grateful for Senator Metz's commitment and passion to ending life sentences without parole to all children. The Senate has before them some very important proposed legislation that would provide a parole hearing for everyone sentenced to life as a youth under the age of 18 after serving 15 years of their sentence. These hearings will be opportunities for a very skilled parole board to assess a person's progress but does not guarantee release. The United States Supreme Court determined that life without parole violates a juvenile offender's constitutional right under the 8th Amendment to be free from cruel and unusual punishment, and the Rhode Island Supreme Court has affirmed this. We believe that by passing this bill, the Senate will help Rhode Island to get out from under the shadow of fear created nearly 3 decades ago and still today, and enact legislation that will safeguard the rights of children. The shadow of fear that I'm talking about is the state demon known as Craig Price. There is no doubt that Price left a lasting legacy on the juvenile justice system in Rhode Island. Public outcry in the early 90s, Price's potential release upon his 21st birthday spurred Rhode Island lawmakers to amend the juvenile sentencing to permit juvenile offenders of any age to be waived into adult court and to be subject to adult sentencing, including life sentence without parole. Juveniles are at a significant disadvantage in the criminal proceedings, weighing long-term consequences, impulsive decisions, reluctance to trust even their own defense counsel, having a limited understanding of the criminal justice system, and not equipped to deal with police or prosecutors, and therefore cannot effectively assist to their own defense. Think about this. Youth are not treated as having the same capacity of adults when it comes to entering into binding contracts, to vote, to marry, or to be able to leave school when they want to. Yet, they are presumed fully responsible as an adult for purposes of criminal process. They can plead guilty, they can go through complicated legal proceedings and be sent to prison to die, without any regard to their age or their diminished capacity. Unfortunately, juveniles, like adults, they commit horrible crimes and they make terrible mistakes, and they should be held accountable, but in accordance with their age, their stage of development, and greater capacity for rehabilitation. A sentence of life in prison is excessively harsh for such a young person, many of whom themselves were victims of abuse and neglect. Over the last few years that I have been involved with this legislation, I am constantly frustrated by articles and comments that I see online and in print from the former AG's office, quote, "I am cautioning legislators to keep in mind the Craig Price murders, and any juvenile defender who finds themselves facing a lengthy sentence, they're truly the most dangerous in our society," unquote. Statements published today and in recent years about Rhode Island's most notorious serial killer from 1990 are meant to regenerate fear over and over again, fear that will blind us from seeing that children are being given a death penalty. By enacting legislation that will ensure that all youth receive age-appropriate sentences and a chance toward rehabilitation, Rhode Island would join 19 other states which now ban this life sentencing without parole for juvenile offenders. Rhode Island's motto is hope. Eliminating life without parole will give every juvenile child offender hope that in the future they will be given the opportunity to demonstrate to the parole board the maturity and the rehabilitation required to obtain release. Today, our hope is that the Senate and House Judiciary committees will work together to discuss and pass this very important legislation. Please vote to bring the bill out of the committee and to the floor. That's all I have. Thank you.
Thank you for your testimony. Senator Metz and then Senator Archambault.
Yes, Dee, this is a pleasure talking to you over
Nice
the
to
phone
see
the
you.
last couple of years.
Yes.
And you're a wonderful aunt. I may start calling you auntie myself.
I know, right?
No, keep up. I appreciate your advocacy.
Thank
God
you very
bless
much. Appreciate it.
Senator Archambault.
Yeah, thank you, and I want to thank you and Steve, and I haven't heard the next gentleman testify, but You did a fine job in your testimony, and I think you underscore the most important point about this. Regardless of the specific facts in the particular case for the individual, after sentencing, they were still a juvenile at the commission of the crime, right? So as a society, we have a paternalistic responsibility to look upon that juvenile with an eye towards rehabilitation. And the bill really comes down to a simple thing, and I applaud Senator Metz for putting this in, and you for your work, and all of you for your testimony. It's when do we look at them with ineligibility for parole? And what is the harm in looking at a juvenile? Plato said that our youth are plastic, the minds are plastic in society. And I'm not minimizing, in certain instances, horrific crimes are taken away from those who've had loss, because we should always have great compassion for anyone who's suffered loss at the hands of someone who's committed a terrible crime. But again, as a society, we have to look at our youth with a mind towards rehabilitation and reintegration models. And is 15 years a reasonable period of time? And I think it is. You know, 5 years, well, that's a little low, right? I think we'd all agree on that. But 15 years, and I support this legislation fully, and you did a fine job in your testimony, and thanks for staying with it.
Might I say that over the years I've read on a lot of statistics and research that has been published on just that item. When is a good time to actually look at a juvenile? They say that the part of the brain that needs to be developed doesn't even occur until they're in their 20s, and I think that's where that 15-year range kind of falls right into where we need to be, plus some, because if they're a juvenile, they're what, 12, 14, 16 years old, and you add 15 onto that, they're a 30-year-old person, so they're well now developed. This is the person that they are at that age. So I think that is a good age, a good range, if you will, where to start looking at the juveniles.
Well, to hop on your theme of hope, there's hope for me yet then, right?
Yes, there is hope for you.
Thank you. Senator Raptakis.
A couple questions for you. You mentioned the fact over and over that the current legislation is like a death penalty for individuals. Now, I just got to make something clear, and I'm not sure. Are you want to repeal the statute that if someone under 18 years old is sentenced to life without parole, or are you reducing the time someone is eligible for parole before they come up in front of the parole board if they get a life sentence with parole? So I just want to understand clearly. So you're looking to eliminate life without parole, and also at the same time where if someone does get life without parole, reducing it from 25 down to 15. You're doing both.
You're talking about two different things.
Well, I want to make sure, because that's what the bill, I want to make sure that the bill says that, and that's your goal of doing two things at once. Not because you keep talking about, I want to make sure clear that you're limiting the death penalty. Of course, we should look at some cases if we have a 14-year-old or 15 or 16 that gets life without parole. That is something I think maybe could be reviewed. But at the same time, you're asking to eliminate that and also reduce the penalty from 25 years, which is current statute, down to 15.
And it's because of the facts and statistics that show that the juvenile brain needs to form and develop well into their 20s before they. Am I getting that right? Do you know what I'm talking about? Yeah. Can somebody help me? Senator
So
Metz.
I can help you.
Yes.
Part of, I think, what we're dealing with here and what we dealt with in years past, and I think maybe Steve Brown may be able to clarify some of these issues for you as well. But the United States Supreme Court has indicated that that sentencing a juvenile to life without parole is unconstitutional. So that is our first issue.
Right.
What this bill seeks to do is put a time frame saying after 15 years they're then eligible for parole. So hopefully that answers your question.
Eligible for parole based on the parole board's findings, assessing them
eligible to seek parole.
Criteria, correct.
Eligible to seek parole. It doesn't mean, and I'm going to start quoting myself here because it's all coming back to me now, but it doesn't mean that the jailhouse doors spring open after 15 years. It means you're eligible for parole.
It begins the process of the parole.
So currently we should not be convicting someone under 18 years old a life sentence without parole.
Well, those are two different things. We can convict them, but we can't sentence them to life without parole.
And the other question I have for you, not a question, but So are we looking maybe to adjust the family court? Because here's the issue. I don't want to throw something that was created because of Craig Price, and you had Woodmansey at 16 years old went and killed Jason Foreman at 5 years old and put his skull on his bureau dresser. I mean, if you got some crimes that are really, really bad,
Very
and I don't
heinous.
think we want to give those individuals
No.
a 15-year eligibility for parole, maybe 25. But the key point that I want to stress, under the current statute, we have someone that's arrested under 18 years old is automatically placed in family court.
But
Then
they start there, though, Senator, to
Say
be
again?
clear. They start in family court.
Correct.
They're not, the trial is not going to happen in family court.
Correct. They have to go through a hearing to be waived from family
Correct.
court and placed into the adult court system.
That is correct.
At the same time, the criteria that we have is the nature of the crime, the violence of the crime, and the mental capacity, whether those individuals understand what is right and what is wrong. And at the same time, I hope that we're looking at an 8-year-old versus a 12-year-old versus a 15-year-old versus someone that's 17 years old in 364 days versus an adult at 18 years old who there's a day difference in age, but they're going to go directly into the adult system. So is that area that you're concerned that maybe we should also look at the current law, and there might be some fault in that structure where we're sending these individuals to be placed under adult court and then face the life with parole and face the current statute of 25 years? Because in order to address your problem, you also got to look why that individual under 18 years old was placed and transferred and waived from family court to the adult court. There's a lot of those. I just picked out the process. So
Senator
that's another
Metz.
area.
Yeah, Madam Chair, if I may, I'm the school teacher. I'm not a lawyer on this, but it was clear to me from the last couple of years of the information that was sent to us and listening to different testimony. Number one, the Supreme Court said you can't sentence someone like that. So that was clear to me. And it was also clear to me that, and I know members of the, for me going to the prison every second and fourth Sunday for my church, I also know that the people from the parole board, if you are that serious a criminal, they'll look at your case, but that doesn't mean they're not going to set you free. So I think that this current legislation and the language covers the point that my brother and colleague is concerned about. But I have confidence in the parole board, and I know what the Supreme Court said, even though I'm not a lawyer. So I just wanted to make that point. Thank you.
Not only that, just to be clear for Senator Raptakis, when the family court has a waiver hearing for the juvenile, the age of the child is taken into consideration, as are all the other facts in terms of mental health, maturity, and those types of things. So there's a huge difference between an 8-year-old, a 12-year-old, a 15-year-old, a 17-year-old. So those things are taken into consideration in the family court. I do understand the concerns that you have in wanting to look at the current law, but I think perhaps there are some other witnesses that may be able to answer better.